This morning I'm going to be talking about South African corporate structures, and just to maybe introduce myself. My name is Liz Pinnock, and for those of you that I haven't met before, I'm head of legal at RSM South Africa. I co-chair internationally the RSM Legal Group, and I'm part of the governance structure of RSM South Africa. I'm a specialist corporate commercial attorney and a B-BBEE practitioner. And when I was asked to put this presentation together, I had to look at the majority of our client base, and they are internationally active clients. And I thought it might be useful at the beginning of the presentation to provide a short overview as to why Africa, and in particular South Africa, is regarded as a good investment opportunity. Now, the slide before you lists a number of reasons why our clients choose to invest in South Africa. And I would just like to focus on a couple of these reasons. South Africa has a sophisticated financial and banking sector, and it's got prudent fiscal management and consistent monetary policies. We have a sound regulatory and legal framework. And this underpins our the commerce and business in South Africa, and in particular, our standouts are the Companies Act, which we know, and King IV on corporate governance. And we have a very sophisticated tax legislation system. South Africa has we have strong sectors in financial services, tourism, agriculture, manufacturing, and ICT. And this allows us to be the gateway into Africa. In addition, there is an untapped emerging market, which is very appealing to our international clients. So with that cursory introduction, I would like to focus on the questions which I'm regularly asked by our international clients when investing in SA. Sorry, I was just thinking we were having some sound issues, but it doesn't appear to be. Next slide, please. Thanks very much. So if I have a look at these frequently asked questions, what our clients generally want to have answers to are the questions that are before you. And these answers often go hand in glove with our tax advice. So what we often find is that initially the advice is given both from a legal and a tax perspective. And the advice takes the form of those initial consultations with the client, and that often results in written opinions or memoranda to the board of the multinational advising on how to invest in South Africa. And for purposes of this presentation, I intend to focus on these questions and the potential answers. 1, type of legal entity. 2, governance structure and limitation of liability. 3, funding. 4, profits and capital remitted offshore. Can we do it? The exchange control implications around it. The next one, statutory registrations. And finally, the one that I'm always talking about is the role of Black economic empowerment. Next slide, please. Right. So if we look at types of legal entities in South Africa, I'm going to touch just briefly on these types of legal entities, and then we'll do a deeper dive into a for-profit private company, which is usually the focus of what our multinationals are interested in. But if we look at a partnership, we know that a partnership is not a legal entity in South Africa. It's regulated by the common law and the principle of what we call utmost good faith. And partners then have rights and duties which are recorded in a partnership agreement. And what we find in these agreements is it records the rights to share in profits, so it puts those participation ratios in, and the obligation on each partner to provide funding and other obligations. The partners, as we know, are taxed individually, and the partners themselves will have unlimited liability as regards third parties. So when we give advice on partnerships, there's got to be very good, sound commercial reasons to exist in establishing a partnership. The next one that we often see is a trust. A trust is a legal entity in South Africa. It's registered with the Master of the High Court. The written trustee governs the relationship between the trustees and the beneficiaries. And that trust deed will also tell us those rights to income and capital that the beneficiaries are entitled to. We know that the letters of authority under the trust that are issued to the trustees then gives the trust the legal capacity to enter into contracts and to act. And this is important. And this is this next point that I want to raise is that if the trust is the alter ego of the founder or the beneficiary, and that alter ego is based on the level of control exercised over the assets of the trust, then the trust structure itself will be pierced, and the founder or the beneficiary will be liable for the obligations of the trust, including those tax obligations. And finally, on this slide, I'd like to chat about a not-for-profit company, something we call an NPC. Now, this is a company that is registered with SIPSI. It is governed by an MRI. It has an appointed board of directors. And usually what we see is that we form these nonprofit companies to conduct what we call a public benefit activity as defined. And this is usually nicely defined in the Income Tax Act. And those public benefit activities are quite wide. It's in Schedule 9 to the Income Tax Act, but it's really dealing with schools, charities. It has cultural interests, social interests, bursaries, etc. And these nonprofit companies then qualify for certain tax relief under the tax legislation. They can have members, these nonprofit companies can have members, and they can hold shares in a for-profit company. And this is what's interesting is that sometimes when we structure certain transactions, this nonprofit company is a common vehicle that we use in BEE transactions. Next slide. Thanks. And continuing on our discussion on legal entities, an external company. Now, this is what a number of our multinational clients opt to register in South Africa, as opposed to forming a South African subsidiary company. This external company is the same legal entity as its parent company. In essence, the external company is the foreign company that is actually conducting business within the Republic. And a good example of what we would classify as an external company is a company which is a party to one or more employment contracts in South Africa. And we usually find that this is a common issue with our multinational clients. Or it is engaged in a pattern of activities which, over a period of at least 6 months, leads one to reasonably conclude that it's engaging in business in South Africa. Now, these external companies must be registered with the CIPC and its company formation documents lodged at our company's office. And although the external company remains regulated by its country of origin, it will, however, be subject to South African exchange control regulations and taxed in South Africa, although there's no absolute requirement for it to be audited in South Africa. So this is where we often find a disconnect with our multinational clients. I think, well, if they're an external company, they're not subject to, for example, ex-con, and that's not strictly speaking correct. And finally, I'd like to chat about a state-owned company. So whilst we are not called upon to register these state-owned companies, a lot of our multinational clients may, during the course of their business dealings, transact with an SOC or a state-owned company. And these are entities that are directly or indirectly controlled by the state. And a good example of this would be Eskom. Next slide, please. Thanks. So if we have a look here at legal entities, and now I'm going to look specifically at for-profit companies, and for purposes of this webinar, this is where I'd like to focus our attention. And the first one is a public company. It's a limited company. You'll see that in its name, limited. It's a legal entity in South Africa. It's governed by our Companies Act. And the important thing is that it is allowed to offer its shares to the public. It's not restricted in that regard. It's registered with our Companies Office, and it's governed by its memorandum and or shareholders agreement. The requirement is that it should have a minimum of one shareholder and at least 3 directors. Luckily, it enjoys what we call limited liability and perpetual succession. So the directors and the shareholders will not be liable for the debts of this company other than the extent of the shareholder contributions, whether they went in as loans or share capital, and the directors if they've acted fraudulently or negligently. The next company I'd like to look at is what we call a personal liability company. It's called an Inc. And this is a legal entity in SA again. Here, though, the directors are jointly and severally liable for the contractual debts of the company contracted whilst they were in office. And where you'll find inks is they're most commonly used for professional firms, and that would be firms of attorneys and auditors. There's no requirement again on inks to be registered and, sorry, not registered, to be audited, unless the ink is what we call a public interest entity. And there's also no requirement for audit unless if all the directors are shareholders. So if all those directors are shareholders, no requirement for audit. And finally, my favorite entity, the private company. This has got a PTY Limited. It's by far the most popular legal entity in SA. It's a separate legal entity. Again, it enjoys limited liability, perpetual succession, and there's no requirements for any shareholder or director to be SA resident. And this is an important point when you're dealing with multinationals. Again, the shareholders aren't liable for the debts of the company, and very rarely will the courts pierce the corporate veil. The company, though, and this is why it's called a private company, the company is prohibited from offering shares to the public, and there is a restriction placed on the transferability of its shares in the MRI. There is no limitation on the number of shareholders and directors. There's also no mandatory audit requirement unless, again, the company is what we call a public interest entity or the shareholders agree to voluntarily submit to audit. And now, what I'd like to do is take we just digress for a moment. I was on a similar presentation with our European colleagues, and there they've got very, very expensive capital requirements, which we'll talk about later in registering a company. If I can have the next slide, please, and we'll take a closer look at the private company and the legislative framework. So next slide, please. Oh, goody. Thanks. So if we have a look at the governance framework for a private company, and here we're going to look at the Companies Act and the MRI. The Companies Act regulates it creates a legal framework for profit companies and not for profit companies. And the Act itself contains alterable and unalterable provisions. And we know that the Act itself will trump the provisions of the MRI and Shareholders Agreement to the extent of conflict. As South Africa, we have adopted what we call the enlightened shareholder approach, which means that we put the interests of our shareholders first, but this is balanced against the interest of the employees, the suppliers, the creditors, the community, and the environment in which the company operates. As an aside, it would be quite interesting to see how this law is developed around those principles of ESG and what Professor Mervyn King talks about as the healthy company. So in addition, the Companies Act has codified the common law as regards directors' duties and responsibilities, and it applies the business judgment rule when evaluating this conduct of directors. The Companies Act itself has no requirement for the introduction of capital to the company, and as such, the barrier to entry on registering a new co in SA is very cheap. It could be no contribution, but just bearing in mind on day one, that company might be technically insolvent. And then the Companies Act has introduced a very neat concept called, and this is called the solvency and liquidity testing. And this applies to any distribution to shareholders, financial assistance to related parties, and share buybacks. And in essence, the company must be both solvent and liquid after that distribution. Now, if we look at the MOI, um, what I like to do with our multinational clients, or any client for that matter, is when incorporating a private company in SA, I would always recommend that the client considers registering a unique form MRI, which speaks to the client's specific circumstances. And this is as opposed to adopting the short form standard MRI, because often I find it's not suitable when I have to actually go in and have a look at the governance issues on a company. So the MRI, we know, is a public document. It's lodged with the Companies Office. It deals with matters of governance. It's binding between shareholders and directors, and it can only be amended by a special resolution of shareholders. Now, here's the trick. Because the MRI is a public document, please, we must exercise caution with dealing with confidential information. And if we are going to deal with confidential information, then this is probably dealt with better in a shareholders agreement. Again, the MRI deals with the powers and duties of directors. It also deals with the appointment and removal of directors. And really, it says that the directors have the authority to bind the company to third parties unless the third party knew that the director lacked the authority. So in practice, it's always best to obtain those authorizing resolutions or minutes to make certain that the person you're dealing with is authorized. The MRI again deals with the voting rights of shareholders. It's very flexible, and this is what makes it so unique, is that the passing of of an ordinary or special resolution, as long as there's 10 points which separate it, the act itself is very flexible, and you can write, so your special resolutions could be 61%, and your ordinary resolutions more than 50%. Also, the MRI will more often than not contain what we call an extended list of matters, which requires a special resolution in addition to those matters in the Companies Act. And these are what we call reserved matters. They're usually contained in a schedule to the MRI. So again, it's just adding another layer of governance into the company structure. And the MRI would probably record that the directors each enjoy one vote in respect of matters to be considered by directors, unless, of course, the MRI states that that matter should be referred to shareholders. Again, the MRI will deal with class of shares, and any version or number of classes of shares can be created, and these can be with or without voting rights, with or without an entitlement to dividends. And this allows us a great amount of flexibility in the design of the capital nature, the capital structure of a company. And again, these classes of shares are usually recorded in a schedule to the MRI. Now, if we take a more in-depth look at the governance framework for a private company, and in looking at the shareholders agreement, this is not a public document. It is binding on all shareholders. The shareholders will sign that shareholders agreement, or they'll sign a deed of adherence to the shareholders agreement. But the good advice what I think is good advice is that if this private company has more than one shareholder, I would always recommend a shareholders agreement to deal with those matters not included in the MRI, and to deal with those matters that are confidential or of a sensitive nature. And the reason being is that often, again, we have to resolve shareholder disputes. And I feel that if you just put those rules down on day one, it avoids any unpleasantness going forward as to what the expectations are of each of our shareholders. Now, what we find in shareholders agreements is something called preemptive rights, where the transfer of shares is restricted between shareholders. They usually set out the value of what those shares would be transferred. It would deal with exit strategies for certain shareholders. It would also detail trigger events, which would cause a deemed offer of shares, and that could be around issues of change of control. It could be breach, it could be death or insolvency. The shareholders agreement would also have come-along provisions to force the minority shareholders to accept an outside offer, so actually go along with the other shareholders, or certain tag-along provisions, and that is to protect minority shareholders in the event of a partial offer of shares. And then funding, this is very important. The shareholders agreement will deal with funding commitments, either by way of loans or by an allotment of additional shares, and the requirements in respect of each of these funding mechanisms. And it'll also deal with the possible dilution of shares should an allotment of shares be the chosen way to fund the business. Then dividends, a dividend policy should be recorded in the shareholders agreement. It could also be recorded in the MRI. And this is a particular minority protection for minority shareholders. And here, directors in South Africa, directors are responsible for declaring the dividends after having satisfied themselves as to the solvency and liquidity test. So it is very important to deal with the declaration of dividends either in the shareholders agreement or the MRI, because directors are the ones that actually control that. So as a shareholder, you do want to have some say on when and how that's going to be. And what we find in shareholders agreements is it also deals with other provisions which are unique to the shareholders themselves and to the business. And that would be, for example, it would determine the basis for the valuation of shares. It could put a formula in. It would list contributions required from shareholders, which are often non-financial, sort of their obligations and what they need to do for the company. It'll deal with stuff like restraints of trade and delegation of authority. So if we look at a private company and we look at funding, what's so interesting under, well, now the new Companies Act, but the Companies Act that we now know, is that there's no requirement in South Africa to introduce a minimum amount of share capital into the company. The test is now based on solvency and liquidity. So will the company be both solvent and liquid after the distribution? For example, the declaration of a dividend, will it be both solvent and liquid? Can it meet its debts in the ordinary course at the time of declaration and for the following 12 months? And the solvency and liquidity test is really a good mechanism because it protects creditors, and so it allows for a great deal of flexibility and a very low barrier to entry when establishing a company in South Africa. Then once the company is registered, what we've got to do is the next step is to open the bank account. And we usually recommend that the client opens a bank account with one of the four large commercial banks. And experience has taught us is that this just allows for ease of the commercial transactions. The banking process takes about 2 weeks to open the bank account. There is a quite a complex KYC. Uh, uh, know your client documents are required. It's quite a complex process, but once it's done, it's done. But the commercial banks understand exchange control, and this becomes critical when you're dealing with multinationals. And then if we have a look at the funding for the private company, um, and this could take a number of forms. One is we can fund our private company by way of share capital, two by way of loans, or three by way of a hybrid of share capital and loans. And for purposes of our discussion this morning, especially if the South African company has non-resident shareholders, then what we do need to bear in mind is that the South African company itself will be subject to exchange control regulations. So let's look at option one. Option one is to fund your company by way of share capital. What this will necessitate is a flow of funds through the SA banking system into the SA bank account. And against receipt of those funds, the shares will be allotted to the shareholder or the offshore shareholder. And if the offshore shareholder, if the shareholder is foreign, those share certificates would need to be sent to the bank to be endorsed non-resident. And the importance of this step is that once those share certificates are endorsed non-residents, it will allow the remittance of dividends and capital to the non-resident shareholder through the SA banking system. What the company will need to do is to present the endorsed share certificate to the bank and the shareholders' resolution. If these share certificates are not endorsed non-resident, and we find this quite often, what happens is that the dividends and capital is going to be locked in South Africa until that position and those share certificates are regularized with the Reserve Bank. Again, funding by way of share capital will ensure that the company will have a strong balance sheet. And from a tax perspective, the dividends that have been declared would be subject to dividends withholdings tax. But obviously, you'd need to look at whether there's any double taxation agreements in place between South Africa and the jurisdiction of the foreign shareholder. Right. Oops. If we look now at option two is funding by way of loans. And this funding is provided by way of a foreign loan. Again, ideally, prior approval should be sought from the South African bank acting on behalf of the Reserve Bank. Once that approval is obtained, those funds can be brought freely through the banking system into the South African bank account. And the important thing with the foreign loan is to determine what is the denomination of the loan. So the currency of the loan would need to be placed on record, and in the event that it's a euro or dollar denominated loan, the South African company will be exposed to those exchange rate fluctuations, and that may result in forex gains or losses. If the loan is rand denominated, obviously that's not an issue. If we look at the interest rate on those loans, again, there's no requirement that the loan is interest bearing. However, if the loan is to be interest bearing and the loan is rand denominated, then the maximum rate of interest on that loan is the SA prime. If the loan is euro or dollar denominated, then the maximum interest rate may not exceed the base lending rate of the country of denomination. So, from an exchange control perspective, provided the foreign loan is approved, both interest and capital repayments may be freely remitted offshore. Obviously, you have to fill in the required documentation at your bank and put your foreign loan reference number in. From a tax perspective, the interest payments are subject to DWT. Again, reference must be had to whether there are any double taxation agreements in place. And as regards the deductibility of the interest payments, this will be subject to SA transfer pricing rules, and the ability to deduct those interest payments from a tax perspective may be limited. In this regard, we usually like to give specialist tax advice to the client so that they understand exactly what the position will be around the loan. And as a third option, we look at the hybrid option. And a lot of our multinational clients do a hybrid option. And what they do is they do an analysis of the funding by way of a foreign loan versus funding by way of share capital. There's usually a split, so it's usually 60-40, somewhere around there. And this solution takes the best of both options. So both the foreign loan option as well as the share capital option. However, we find that when we advise our clients on these, their financial position in each case would need to be assessed. Right. So if we have a look now at statutory registrations, I'm just going to touch briefly on them because I think a lot of you are familiar with it. But obviously, the private company will be registered with SIPC. The directors will also be registered, will be placed on record with SIPC, but there's no requirement in South Africa for the director to be a South African citizen. So directors can be non-resident. Then we look at tax registrations. That has to happen. Income tax, PAYE, VAT, UIF, SDL, you name it. That's what has to be done. And then finally, the public officer. The public officer is responsible for the tax affairs of the South African company. But the requirement is that the public officer has to be resident in South Africa. So practically speaking, for our multinationals, this does create some problem. And usually what we find is that the South African CFO, the CEO, or the financial manager will usually accept that position. And then finally, my favorite topic, and a lot of you might know that we do a lot of work in the BEE space, but all of our multinational clients, when coming to do business in SA, when investing in SA, BEE is a very, very important issue. And it's one that we spend a lot of time advising our clients on. And the first question they always ask me simply is it a legal requirement to do business in SA? Do we have to have some form of Black economic empowerment? The short answer is no, there's no legal requirement. However, if the South African company is going to do business with government or with state-owned entities and it has to tender, it will be required to submit for a BEE verification certificate. So then if it's not a legal requirement, then what is it? And what we find is that it's a strategic requirement. BEE has a strategic, is usually a strategic commercial requirement for our client. And when we do the analysis, what you'll find is it plays out in the company's supply chain, where procurement plays a very, very key role. So if the company, in order to secure work or contracts, is reliant on its level of BE compliance or level of BE ownership, and it needs that to be competitive and to have a competitive advantage, then obviously it will have to develop a BE strategy, and it would have to submit itself for BE verification and a certificate issued. So what does the certificate do? Well, it measures the level of Black economic empowerment, and it measures ownership, management control, skills development, enterprise and supplier development. And that includes procurement and socioeconomic spend, all in relation to Black persons. So that's really kind of the end of corporate structures in South Africa 101. I'd just like to thank everyone for their time this morning. Sorry for one or two technical issues. But if you would like to get hold of me to continue the conversation, or if you just need some help on some of these issues, please feel free to email me or drop Denise an email, or pop a query on our website. My email is liz.pinnock, PINNOCK, at rsmza.co.za. And with that, thanks. Have a great Friday, and till we meet again.